Okay, so let's turn to Donald Trump. He has the right to be at his trial. Absolutely. If they tried to ban him from his trial, there would be a constitutional violation. I've argued such cases. I've won such cases. But the government has no constitutional right to make him be there. So there's a statute in New York, and I haven't seen it quoted, and I'm surprised because the statute does permit a motion to be made to allow a defendant not to be at the trial, for example, to go to his son's graduation or to listen to the Supreme Court very essential argument next Thursday about whether a president has some kind of immunity. And he tried to get that, and the judge said no. And he tried to get permission to go to his son's graduation, and the judge hasn't ruled on it, but made it fairly clear that he'd rule against it. Well, here's the statute. It says, on motion of a defendant, the court may, not must, but may. But here's the critical phrase. The court may, and this was probably put in at the end because it's ungrammatical. The court may, in the absence of an objection by the people, that's the prosecution, issue an order dispensing with the requirement that the defendant be personally present at trial. Such an order may be made only upon the filing of a written and subscribed statement by the defendant declaring that he waives his right to be personally present at the trial and authorizing his attorney to conduct his defense. Well, I'm sure that Trump would sign such a letter allowing him to go to his son's graduation or allowing him to go for a day and campaign in Pennsylvania when Biden is there campaigning in Pennsylvania, a crucial state that could determine the outcome of the election. But the statute says, on motion of defendant, the court may, in the absence of an objection from the people. That's unconstitutional. You can't give that decision unilaterally to the prosecution. That decision should be made by a judge. Even if the prosecution wants him there, they have no right to be there. And his right, his First Amendment right to campaign, his familial right to go to his son's graduation, though that's not protected by the Constitution, but his right to campaign is protected by the Constitution, trumps any interest of the state in having him at the trial. The state has no interest in having him at the trial for a particular day, maybe if they want him to be identified. But in general, if there's a day that he'd rather be home watching television, he should certainly have the right to do that. But putting that aside, if he's not home watching television, if he's in Pennsylvania campaigning or watching a Supreme Court argument, surely that right prevails over the illegitimate non-interests of the prosecution in having him in the court. So whoever wrote this statute, I'm sure what happened is it was originally written on motion of the defense, the court may issue an order. And then a prosecutor said, well, no, we want to have a say here. So somebody added, I guarantee you, somebody added the phrase, the court may, in the absence of an objection by the people. Unconstitutional. I don't know whether Trump's lawyers are aware of this. I don't know if they've made a motion. Maybe they have. Maybe it's been denied. If it's been denied, it should be appealed, because it seems to me quite clear that a defendant has a constitutional right not to be at his trial.